Hello and good morning, everyone. Thank you so much for joining our webinar this morning, the Mortgage Quality and Compliance webinar. My name is Marty Allred. I'm Vice President of Compliance for American Pacific Mortgage Corporation. And as always, we're excited to see the attendee numbers keep going up and up and up. So we have a great group joining today. And we do these monthly, just as a reminder. So please let your colleagues, friends in the industry know about these webinars. It's a great way to get information about compliance and quality assurance and best practices in our industry. I do want to mention today some of the upcoming events. These are posted on California MBA's website, so cmba.com. If you go to the upcoming events area, there is a Santa Ana After Hours event on June 21st. And in July, the 16th through the 18th, is the annual Western Secondary Conference in San Francisco. And in August 5th through the 7th, is the annual Western States Mortgage Technology and Loan Servicing Conference in San Diego. And also, Justin made me aware that they're getting ready to post some networking events, basically about one a month. Those are going to be on the website here very soon. And those are free to anyone in the industry. So again, let your colleagues and your friends in the industry know about those. Great way to meet new people, network with others in the industry. And those, again, are on cmba.com. So we're going to go ahead and get started today with our monthly California legislative update from our California MBA lobbyist with KP Public Affairs, Pat Zenzala. Pat?
Thank you, Marty. So I'll start, before I start talking about bills, just to let the group know where we're at in the legislative process. We're getting close to being done with the first half of the process. All bills have to be out of the House of Introduction by May 31st, so by the end of the day, May 31st. So we're going to have hundreds of bills heard on the floor next week, and so it's going to be a very active time, and hopefully many of the bills will not move forward, because I can say that there aren't a ton of bills that need to move forward as far as creating new policy in California. I think we have quite a bit as is. Start out with AB 2368 as far as bills that I want to talk about. This bill is actually one that we are co-sponsoring. The California MBA is adopting some model language that the national MBA put out on remote notarization, and we are trying to use that language and have it in AB 2368, and essentially try to bring the process up to date from a technological perspective and allow for remote notarizations to occur. The bill has moved through Policy Committee. It's an Appropriations Committee, and we should know tomorrow whether it's going to pass out of Appropriations Committee and move to the floor. So anyhow, that's a very positive bill, and we think that this will help make the process more convenient for lenders and for consumers. The next bill, SB 818, is a bill that we actually oppose. This bill would reinstate provisions of the California Homeowner Bill of Rights that expired at the end of 2017. Essentially, these are the provisions that apply to mortgage originator servicers that have experienced 175 foreclosures or more in the previous 12-month period. And so they did expire. They sunset at the end of last year. Now we have this bill, SB 818, that would attempt to reinstate those provisions. And if they do reinstate the provisions, if this bill does pass, they would be effective January 1st, 2019. So we oppose it. We don't think it makes sense to just do a wholesale reinstatement. We've been trying to work with the author and the sponsors of the bill to see if there's a way to narrow the focus, see if there's just, a certain set of provisions that, there's a need to reinstate for some reason. And then also we're seeing if there are opportunities to better align the California Homeowner Bill of Rights as far as processes with the national servicing standards. The bill is passed out of the first house, so it's passed out of the Senate, and it will be heard in the Assembly Banking Committee likely towards the middle of June. And then the final bill I wanted to briefly discuss today is SB 1201. This bill is sponsored by the Department of Business Oversight, and the main portion of the bill would essentially build on existing requirements that we have, mortgage loan originators have, if we negotiate a mortgage in one of 5 specified languages. So in other words, you're negotiating it in Spanish, Chinese, Tagalog, Vietnamese, or Korean. You would need to provide a summary document in that foreign language about the key terms of the mortgage. That's existing statute. This bill updates the forms that we would use that are provided by the Department of Business Oversight on the origination side. And then second, it would also apply the translation requirement if we negotiate a modification also primarily in one of those languages. Originally, the bill would have required all modification forms to be translated. We were successful in obtaining amendments that limited the requirement to the existing requirement that we have, so that the DBO would provide a translated summary form, and we would be able to use that summary form if we negotiate in those languages. So it adopts the process that we've been using for years, but now it would apply to modifications. So if this bill passes, also it would be effective January 1st of 2019. So that's it, Marty, as far as my bills that I wanted to summarize.
Okay, great. Thank you very much, Pat. That's some great information, and it certainly sounds like you're going to be really busy next week with all those bills to review. So thank you again for all the work that you do. On to our litigation update. We have Michael Pfeiffer with Kirby and McGuinn, and who is also General Counsel for the California MBA. Michael?
Good morning, everyone. Thank you, Marty. The case I'm going to talk about today was issued by the U.S. Supreme Court earlier this week on Monday. Came out with this decision, Epic Systems Corp versus Lewis. Many of you may have heard about it. I'm not sure, but I think it's an important case to talk about for a couple of reasons. One of which is that the California MBA participated in an amicus brief to the U.S. Supreme Court in connection with this case. The factual background is that this case, which was consolidated with 2 others, it involves basically rights of employees and between the Arbitration Act and certain provisions of the National Labor Relations Act. In this case, as in all of the cases, there was an employer and employee who entered into a contract to provide individual arbitration proceedings to resolve employment disputes. And in each case, the employee sought to litigate claims under the Fair Labor Standards Act through class actions in federal court. And this is important because the Federal Arbitration Act generally requires courts to enforce arbitration agreements as written, but the employees argued that there's a savings clause in it which remove that obligation if the arbitration agreement violates some other federal law, and that by requiring individualized proceedings, the agreements violated provisions of the National Labor Relations Act and prevented employees. It took the NLRB, National Labor Relations Board, took a kind of a novel position and argued that the NLRA protected the rights of employees to bargain collectively and engage in other, quote, concerted activities for the purpose of bargaining or other mutual aid and protection. Next slide. The employers in the case said, wait, and none of these were mortgage companies, by the way, said that the NLRA protects agreements requiring arbitration from judicial interference, and that neither the savings clause or the NLRA offered a different conclusion. Previously, the courts, including the NLRB, at least their general counsel, had agreed that to this position. But in 2012, and it was kind of considered an aggressive move to change things, the NLRB ruled that the National Labor Relations Act nullified the Arbitration Act, and then the court started following the board's position. In 2017, this case came forward. We filed an amicus brief along with the National MBA, the associations in Colorado, New York, and Ohio, and Texas, in support of the employer's position. And on Monday, the court came out with its ruling. Next slide. Basically holding that Congress had instructed in the Arbitration Act that these agreements providing for individualized proceedings must be enforced, and that neither the Arbitration Act savings clause nor the National Labor Relations Act suggested otherwise. That sounds like a simple result, but it was very bitterly contested and divided the court. It was a 5-4 decision. The decision was written by Neil Gorsuch and with a concurring opinion by Justice Thomas, and a dissenting opinion written by Justice Ginsburg, joined by Justices Breyer, Sotomayor, and Kagan. So you can see it sort of divided on political lines. And this is a difficult issue, but has tremendous impact on the operations of people's businesses. I've been following on the SCOTUS blog, the Supreme Court of U.S. blog, all the different comments on it, and the general counsel for the Service Employees International Union has piped in and said basically the decision was, quote, the latest assault on workers against workers by the Supreme Court. She said that the decision gave another victory to anti-worker extremists trying to get employees to forfeit their decades-old right to join together with co-workers in a class or collective action, and to pursue claims for stolen wages, sex, race, age, or other discrimination in workplace claims. She asserted that Neil Gorsuch manages to twist the meaning of these statutory provisions and creates a setback for workers everywhere, going back even to pre-1920s. So obviously there was pretty strong feelings about the political significance of that. Another commentator basically said just the opposite. Good news for employers and workers, bad news for lawyers. Obviously, this decision curtails the ability of lawyers to file class action lawsuits. Another commentator, I thought, said some very interesting things, and this will be my sort of final comment on the commentators, which addresses the dissent in the case by Justice Ginsburg. This is the chief counsel for the Washington Legal Foundation, who also filed an amicus brief, and they said that, and there were all kinds of amicus briefs filed in this case. It was a major decision involving the rights of employers and workers throughout the country. He said the majority dissenting opinions adopted starkly competing visions of two federal statutes, both nearly a century old. The majority held that the Federal Arbitration Act policy favoring enforcement of arbitration agreements trumps, with a small t, Section 7 of the National Labor Relations Act, which confers on employees the right to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. In contrast, Justice Ruth Bader Ginsburg's dissent argued that the rights conferred by Section 7 take precedence over the FAA and prohibit enforcement of agreements calling for one-on-one arbitration of employment disputes. He argues that there was a major flaw in Justice Ginsburg's dissent in that she relied significantly on Rule 23 of the Federal Rules of Civil Procedure providing for class actions, which was not enacted until 1966. But she's using that as an argument to support her interpretation that the two federal statutes enacted over 100 years ago intended basically to allow class actions for National Labor Relations Act claims. So this illustrates the stark political positions of some of the justices in the court, but it is definitely a win for employers. And a lot of people feel that's also a win for employees because these arbitration clauses do result sometimes, not always, but sometimes in more rational decisions for the employees. But it takes away the class action hammer of organized activity. So that's my report on that case.
Great, thank you, Michael. Appreciate that update on arbitration and employment law, and like you said, it does sound like positive for employees and employers, so thank you for that. Okay, so we're going to move into our main topic today, which is hot topics in state examinations and regulation. And we have two extraordinary speakers today, Monika McCarthy and Kitty Ryan. Let me tell you a little bit about each of them. Monika McCarthy is the General Counsel and Managing Director at CrossCheck Compliance, LLC. As the company's General Counsel, Monika advises the firm on ethics, conflicts of interest, governance, internal controls, risk management issues, contracts and vendor management, and also provides guidance on client matters. Monika brings her passion for building relationships and connecting people to the company's business development activities. Her unique experience as both in-house counsel and outside counsel working with public, private, and startup companies enables her to add valuable insight to CrossCheck's engagements with mortgage companies, banks, credit unions, and fintech companies. Her work frequently involves partnering directly with in-house counsel and outside counsel to provide strategic advice and help clients both mitigate risk and cost-effectively scope engagements. And Kitty Ryan is a partner at Akerman, LLP in Los Angeles, a former Deputy Assistant Director for the Office of Regulations at the CFPB. Kitty guides clients through the financial services landscape. She has extensive experience advising clients on mortgage regulations, bringing not only the perspective of a former regulator, but also her experience as in-house counsel for JP Morgan Chase. She focuses her practice on mortgage origination and servicing and fair lending and regulatory compliance matters, including state laws, as well as the Home Mortgage Disclosure Act, HMDA, the Truth in Lending Act, TILA, and RESPA and UDAP. Monika and Kitty, we are so honored to have you speaking about hot topics in state regulation. Go ahead and take it away.
Monika, this is Dustin. I think you may be on, you may have muted yourself, so we can't hear you.
Appreciate that, Dustin. Thanks so much. And want to appreciate Marty's introduction. And we'll move right on to the legal disclaimer, which is simply designed to let you know that if you have specific questions for your entity, you can direct them to us. And the information we're going to give you is pretty much general in content. I want to start with an overview of what today's presentation will cover. And the materials will be available on the CMBA website. So first, we're going to cover some of the current regulatory environments and the trends in the industry. And we're going to then move on to some of the unique state-specific issues and exam focus. And hopefully we'll have a few minutes left at the end for questions. I do want to acknowledge the many clients and colleagues of both Kitty's and mine who have contributed their insights and experiences to some of the materials that we'll be able to share with you today. So first, for the current regulatory environment, Kitty, do you want to share with us some of the CFPB background and what's been happening?
Sure, thanks, Monika. So this is a webinar on state regulatory trends, and so you might be wondering why we want to talk a little bit about the CFPB, but I think it's important to set the table for you as to why we are all so focused on state regulatory trends. As you know, in November 2017, Richard Cordray, the CFPB's first director, resigned to run for governor of Ohio. President Trump temporarily appointed Mick Mulvaney. He can remain in as a temporary director until sometime next month. However, know that Mick Mulvaney could be staying for a while. If the president names somebody before that time ends for Mr. Mulvaney, then he can remain while that nomination's pending. If the Senate rejects the nominee of the president, then Mick Mulvaney can again stay on for a while. So while there's a lot of uncertainty, it seems likely that we may be seeing Mick Mulvaney for a while, although we don't really know that. But the bottom line is that all the signals from President Trump and from Mr. Mulvaney is that they really want to take a kind of deregulatory approach to the consumer financial spectrum. Mulvaney early on made it a point to say that he would no longer allow the agency to be as aggressive in enforcement, that he would not allow them to continue to push the envelope. Now, not all of the CFPB's actions were taken against the mortgage industry, but many were, including the redlining cases and others, and many of their other enforcement actions had implications for mortgage, even if they were not taken against mortgage industry actors. So this obviously was a huge development for everybody. Other developments that Mulvaney has put in place are to reorganize the Office of Fair Lending Enforcement and Oversight and the Student Servicing Office. While these might not be immediately impactful to you, this is a very strong signal that these areas are not going to sort of receive the special attention that they did under Director Cordray. Just a word, though, about fair lending, particularly for those of you involved in mortgage. HMDA data is still there. Supervision is still there, and I would expect that we will continue to see some emphasis on fair lending in the mortgage market, but we may not be seeing public enforcement actions. It may be private, it may be behind the scenes during an examination, so no one should relax on fair lending. I also want to say a couple of words about the CFPB's approach to rulemaking. As Susan mentioned in the introduction, that was my area at the CFPB. I've also worked on mortgage rules at the Federal Reserve Board for more than a decade, so this is all very near and dear to my heart. In terms of rulemaking, while Mulvaney has said that he wants to pivot away from regulation by enforcement, he's also said he wants to have the rules of the road be clear to people so that when they are tagged with an enforcement action, the idea is that they would have known in advance as to what they were expected to do. He has said that he intends to revisit the HMDA rules that the CFPB put in place in 2015. Those recently took effect in January, so we're already well into implementation of them, but nevertheless, Mulvaney has said he intends to revisit those rules. It seems fairly clear he wants to find ways to reduce the burden on smaller HMDA reporters. And in the CFPB's recently published Unified Agenda, he announced that he expected to have a notice of proposed rulemaking on HMDA in January 2019. Now, the Unified Agenda isn't binding, and oftentimes an agency will give a date like that and then go past it, but it's a fairly clear signal that he intends to work on HMDA. The other significant action is he has indicated in that Unified Agenda that he expects to have a debt collection rule out. However, it appears to be something at a scale back from what the CFPB was contemplating earlier, in that it will probably only apply to third-party debt collectors under the FDCPA. So it won't apply to creditors who are collecting in their own name on their own accounts. And it's probably going to be a package that will clarify some of the confusing aspects of the FDCPA for both the industry and for consumer advocates, and will probably focus on information and disclosures and consumer contacts. The other interesting development is that the acting director had said a few weeks ago that he thought that the CFPB's ability to repay qualified mortgage rule was probably constricting credit and was too burdensome. And so that sounded like another candidate for him to look at in a future rulemaking and ways to reduce regulatory burden. Which brings us to the fact that a couple of days ago, the Senate Bill 2155 passed the House. This was a bill that was introduced by Senator Crapo. It's called the Regulatory Relief Bill, and it would roll back some of the Dodd-Frank Act protections. Many of them don't apply specifically to mortgage, so I just want to talk about a couple here. Continuing on a similar theme, if the Reg Relief Bill would dial back HMDA reporting burden for small banks and credit unions, they would basically still be required to report HMDA data, but they wouldn't be required to report the expanded data that Dodd-Frank put in place and that the CFPB put in place in its 2015 rule. The reg relief bill would also extend qualified mortgage status to loans made by banks and credit unions with under $10 billion in assets if they hold those loans in portfolio and they meet a few other qualifications. So this is obviously a big victory for those banks and credit unions in terms of the qualified mortgage rule. The question is whether when Mulvaney goes to implement that change to his rules, whether he will consider extending any relief in any more broader sense on qualified mortgage and on ability to repay. Then lastly, one thing I want to mention about 2155 is it also requires the CFPB to issue rules to impose that Dodd-Frank Act ability to repay standard on PACE financing. PACE stands for Property Assessed Clean Energy. If you're not aware of what it is, it's a special tax assessment that allows a homeowner to finance improvements to the home that are really geared towards clean and renewable energy or retrofitting the home for earthquakes or hurricanes and the like. California has been a leader in that space by enacting its own legislation to impose ability to repay on administrators that are operating within California. So I think the question is whether the CFPB will see California's law as a blueprint, perhaps, to follow, or whether it will take its own course. So, as I said, I wanted to set the table for you on where the CFPB is. It clearly seems to be stepping back in many respects, and to the extent that it's active, it seems to be looking for ways to almost deregulate or scale back regulations. And on a very pointed note, Mulvaney said in February to the National Associations of Attorneys General, why we think we know better how to protect consumers in your state surprises me. And he also said we are going to be looking to the state regulators and the state attorneys general for a lot more leadership in this space. So I'm going to turn it back to Monika for her thoughts here.
Great. Thanks, Kitty. So that's really a good landscape for you for what's going on. And what we're really seeing is that the states are being asked to step up, and the states are stepping up, and the states are expressing their feeling about what's happening with the CFPB at the same time. There will be an article coming out from MBA with regard to some of this as well, and highlighting the role of the attorneys general. And I think this is interesting to point out for folks to be aware of, that the attorneys general are each being active individually in their states. You'll hear more about that in our presentation, but that they also belong to a national association of attorneys general. They also belong to the Democratic Association of Attorneys General or Republican Association of Attorneys General. And those associations each have committees that are very focused on consumers and that are also focused on financial institutions and their activities. So what happens is that they are sharing information amongst their committees and amongst their groups. So a lot of what you're going to be seeing with the states is, and hearing about, is the sharing of information and how that is going to impact you with one state exam, and share that information so that other states will similarly have that information, be able to act on it. So, Kitty, do you want to talk a little bit about some of the comments that have been out there?
Sure. So this seems like an unusual sort of situation to me, and maybe it's been repeated in our history and I just wasn't paying attention, but some states have been very, very vocal and very specific in their views about the CFPB stepping back and the general posture of the Trump administration on consumer financial protection, including mortgages. So we see statements by the New York State Department of Financial Services Chief, Maria Vullo, early on saying she was very disappointed in the policy shift. You had numerous Democratic attorney generals sending a letter to the director sort of decrying the way that the CFPB was turning, and Mulvaney's statements about less enforcement. So these things might not seem that surprising given we're used to states like New York, California, New Jersey, a handful of others, being very much leaders in the consumer financial space. But what seems particularly sort of interesting to me is we see other states jumping in here. So the 17 Democratic AGs who sent that letter, it includes states like Virginia, Hawaii, the District of Columbia, Maryland, other states that we aren't as used to a big focus on consumer financial protection from. And the other thing I will say about that is some of those states have tended to focus their resources away from mortgage on consumer financial protection, but it certainly is instructive and could mean that eventually they will get to mortgage just because it is such a big market, and particularly in the area of mortgage servicing and loss mitigation, where policymakers tend to view consumers as being very vulnerable and they can't change their servicer and their home is at stake, and so it can be a very compelling issue for an attorney general. So in Virginia, the attorney general has focused a lot of resources on combating payday lending and online payday lenders, but one wonders if he will continue that or if he will spread his resources out a bit and look more at mortgage as well. The other development is that our former CFPB director, Richard Cordray, when he left in November 2017, he went to run for governor of Ohio. That's his home state. He was the attorney general there before he was at the CFPB. So he returned, and I think he surprised a lot of people by securing the Democratic nomination very recently for that race. So he'll face off against the Republican Mike DeWine in November. So we can sort of doesn't take a crystal ball to see that if Mr. Cordray were elected, he would likely take a very aggressive posture towards consumer financial protection in Ohio and would almost certainly join with the other AGs. As Monika has mentioned, they have many associations. They have both formal and informal working groups. So we would expect him to be a part of those and most likely to be a leader or looked upon as a leader in those groups, given the sorts of things that he did at the CFPB.
Great. So there's a clear demonstration of states stepping up. So let's talk about what we are seeing at the state level, some of the trends. So one of the first trends is that we're seeing a continued focus on servicing. Here, regulators often focus on mortgage servicing, as Kitty said, because they view borrowers as, without any leverage. They can't walk away from a servicer that isn't fulfilling its legal obligations to the borrower. So regulators have often, they hone in on the default servicing because they're concerned that borrowers may experience a wrongful foreclosure. So in Massachusetts, they have focused on a number of issues. So these include the alleged duplicate release and recording fees and servicers charging late fees in excess of their state's limits. Massachusetts has also joined with other states in settlements with large national servicers, and those have focused on allegations that these servicer systems were deficient in numerous ways, including sending notices to borrowers in an untimely fashion, sending incomplete notices, failing to keep records, or to be able to evidence compliance with rules and other pervasive issues. Then in California, they've also joined or even led these multi-state settlements of large servicers. These have included allegations that the servicers did not comply with or could not produce evidence of compliance with the CRMLA, the California Homeowners Bill of Rights, the FCRA, FCRA, and CFPB's mortgage servicing rules for loss mitigation. So these servicers were alleged to have inadequate or even non-existent policies and procedures and controls over their own operations, as well as inadequate oversight over third parties. We continue to hear a lot about the requirement of oversight of your vendors and vendor management, and that trend has continued. For example, some of the servicers allegedly had inadequate oversight even of their foreclosure counsel. So that is, again, an area that is still under scrutiny by California as well as other states. As we've seen, California has also settled with several servicers based on allegations that the servicers were not properly licensed. And a very common charge in these cases is that servicers allegedly did not comply with California's restriction on per diem interest. We've all been hearing about that, the exams and the calculation of per diem interest and the focus on that. And, you know, as most of you know by now, that is with regard to specific statutory requirements, it was designed to let the lender collect more per diem interest, but the issue is on documenting the actual dates that are at issue to be able to calculate the proper amount of interest that was retained and charged. So again, in California, those are issues that continue to be focused on with their servicers. So next up, we have some additional resources and changing laws at the state. One of the big things playing off of what Kitty was sharing already was resources are definitely being added by the AGs in certain states. And there are announcements being released for that. You should also know that you can go to your state AG and sign up for alerts coming out of their office so that you can be very aware of what their focus is and what press releases and things they're giving out. You can also sign up with some of those associations as well. We've seen many CFPB divisions formed, both in New Jersey and in Pennsylvania, and partnering with the AG and with the governor, coming out to really assert the failure of the CFPB and to identify that they are compelled to fill the void and are expanding where they are putting their resources. And as Kitty said, it doesn't always identify solely mortgage, but it does address protection of consumers. So that's what we're seeing there. Kitty, do you want to cover Maryland?
Sure. So Maryland, in response to the change in administration, enacted a law that sets up a Financial Consumer Protection Commission. It's set to sunset in 2019, but I wouldn't be surprised if it isn't in some way continued at some point. And again, it's a very public demonstration that they believe that the federal government isn't going to be appropriately protecting consumers, and that they, as a state, need to step up and fill that void. We heard earlier about the potential amendments to the California Homeowner Bill of Rights and a nice summary of that amendment. I think what I would say about California's Homeowner Bill of Rights and some of the other state laws, particularly around servicing, is it's important to remember that while the CFPB has servicing rules that are very detailed and very prescriptive, you also almost certainly have state rules as well. And you have to comply with both. The federal rules don't preempt the state rules for the most part. And so even though they may be slightly different, one has 5 days for something and one has 3 days for something, you have to comply with both, and you have to keep in mind that there are different penalty schemes for each of these laws. So, for example, in California, there's private right of action for some of these provisions. There are statutory damages. The CFPB's rules do provide for private right of action and damages, but only for certain provisions. Certainly for loss mitigation, there's private right of action, but not always. So you have to be in compliance with both laws to really have maximum protection against potential lawsuits or other actions. And I want to touch briefly on some of the changes to state licensing laws that we've seen and just highlight maybe one for you, which is Pennsylvania. So Pennsylvania recently changed its mortgage licensing law to make clear that mortgage servicers will have to have a license to engage in the mortgage loan business, which they say now includes servicing mortgage loans. So if you're servicing on behalf of others, you have to get a license. I think the date has already passed for that. If you are not aware of this, you should definitely look into it. It is a way for a state, and in this case it's Pennsylvania, to have jurisdiction over you, to be able to come in and examine you, to be able to investigate very easily without having to first justify the need to do that. The other significant development in Pennsylvania, which is not about licensing, but kind of goes back to our main theme here, is Pennsylvania at the same time also incorporated all of the CFPB's loss mitigation servicing rules into its state code. I think, you don't, again, have to read the tea leaves to figure out why they might have done that. They did that because they were likely concerned that the CFPB would not be as enforcement-minded as it has been in mortgage servicing. And this gives Pennsylvania the ability to take those same rules and enforce them as their own. So an important step there, and I think we will see similar actions elsewhere. On lead generation, just a quick note, because we may touch on it in other places. Many states do require lead generators to be licensed, but Connecticut recently enacted a sort of special licensing requirement for lead generators. So the bottom line here is that the states are looking for ways to expand their reach over actors in the mortgage market, not necessarily those who clearly are making loans, but others who touch the origination process or who service or have any sort of touch on the mortgage industry as it relates to consumers. We see this sort of creeping expansion of the states in their laws. So it's an area that you have to just keep watching.
Great. Thanks, Kitty. So next, what we are going to look at is some general trends in the mortgage sector. And here what we've got is, to start off with, we're seeing the state's exam requests for information are more robust. And they're becoming more CFPB-like. They're very much trying to mimic what those examinations are. And we're also seeing a switch to a little bit more of a risk-based approach and a focus there. And you'll hear a little bit later about some of the individual states as to what they're doing. But I've clearly been hearing and seeing that a lot of the states are just really, their RFIs are just much broader, taking a lot more time for everyone to comply with. So the time limits for that are still pretty tight and short. So just be aware of that. One of the additional complaints that we're seeing a lot about is that the regulators are sharing information. So what's happened is that their actual requests for information in their exam report are asking for you to produce the exam report for any other state exam that you had since the last examination with the particular state that's now doing an exam. And they are, in fact, permitted to do so. And this sharing of information really goes to show that, the issues that you have are, there's going to be transparency. And even if the CFPB is not aware of it and sharing it, then the states are amongst themselves sharing the information. And again, we already talked about it, but the AGs are very much lining up along party lines and through NAG to try to use some of the information to then benefit for where they believe they should advocate on behalf of consumers. So we're seeing that as well. And Kitty, can you share with us some of the formal coordination that is taking place and what's permitting that?
Yeah. In terms of coordination between the states, the CSBS and the AARMR, hopefully you all know what those acronyms stand for by now, they really began their coordination before these recent changes to the CFPB. This really grew out of the mortgage crisis. So in 2009, they formed this multi-state mortgage committee and really got down to the business of making sure that they shared their resources so that they could focus on non-bank mortgage lenders. Now, keep in mind, one of the things that's significant for the states is, unlike the CFPB and some other federal agencies, they don't have the budgetary resources that those agencies do. So an agency like the CFPB, its entire budget is there really for consumer financial protection. And in the CFPB's case, they don't have to go to Congress for a budget. They basically draw on money from the Federal Reserve Board. So they really have a lot of resources at their disposal. And the states, of course, in every state, consumer financial protection is competing with however many other, myriad issues are impacting that state and its policymakers. So for the states to get together, they realized that they needed to pool their resources to really focus on the mortgage market, and that's what they've done. So in order to be able to share things like examination information, which is ordinarily confidential, they all sign a non-disclosure agreement and detailed procedures about what they will do if that information is somehow requested from some third party. So that's part of how they're able to do what they do. And so the MMC really focuses on those lenders that are operating in multiple states. Again, scarce resources, you're going to focus on the bigger players for your operations, but that doesn't mean that they aren't looking at others as well. The other thing that we see the states doing is looking for those who may be operating in their state without a license. So I mentioned a slide ago that they seem to be increasing the scope of their licenses, and here we see them taking even their existing licensing requirements and then looking to see if people are or companies are in some way coming into their state, reaching their citizens with mortgage products and offerings. And one of the ways that they do this is through complaints. The other way that they do this is by looking at marketing. We know that we have the wonderful internet and we have social media, and it's all free and it's all out there for loan officers to use. And this is a way that almost anybody can go and see whatever they have put, publicly on Twitter or anywhere else. And it's a way to kind of get a gotcha on somebody who may be infringing, or in the state's view, infringing into their state without acquiring the right license. And just a word on complaints. The CFPB's database on complaints has long been a bone of contention with everybody. They make the narratives public, if the consumer consents, and they make a lot of the information otherwise in that database public. Mulvaney has indicated that he no longer is going to make all that information public. So I think while that has caused some people in the industry to kind of sigh in relief, keep in mind that state AGs will still have access to everything in that database just as they do today. So this is a very good way, a very effective way to look for activity in a particular state and see if people are complaining about somebody, and then go see if they're licensed in the state. So some important things to keep in mind there when you're thinking about marketing and social media, and also your own complaint activity. Make sure that you're monitoring that.
Yeah, and one of the other points that I would want to make, and it's been talked about at other of the MBA conferences, is the NMLS changes and the development of and use of these systems and data systems, where it's really going to permit the regulators to collaborate and share all the exam content as well. And there's just a real push towards making that happen. So again, just lots of transparency. And even if the CFPB isn't going to put out a lot of this information, the state regulators are going to be sharing it amongst themselves. So for some more general trends, we're going to kick off with some of the cyber trends.
So this slide, we want to talk a little bit about security, and there's sort of two flavors of risk and concern here, and one is just data security in general. So cybersecurity, in the wake of the Equifax breach, obviously has been front and center for regulators, both at the federal level and at the state level. And we see states feeling that they really need to step in and take some action. But the other risk that we see, and the other big concern, is in the wake of the whole issues with Facebook and third parties being able to access information about people on Facebook without people understanding that that was the case, is a sense of privacy of my information that might be out in social media and my browsing history and things like that. So we do see activity here. California there is apparently a proposed ballot initiative that has gotten, I think, nominally at least enough signatures to be on the ballot in November. I think it's the California Consumer Privacy Act. It is a very sweeping piece of legislation that, if it isn't changed, would have a very broad impact on the mortgage market as well as others. It is certainly not limited to mortgage, but it would clearly, as written, sweep in originators, servicers, lead aggregators, almost anybody who has any information about consumers. One of the most striking points about the legislation is that it defines personal information to include browsing history. It also has provisions for private right of action, so borrowers can sue. There are statutory damages. The legislation makes very clear that the person does not need to show any actual harm. They would be entitled to damages. And it also authorizes what we call qui tam litigation, or that is a case brought by a private citizen. They approach the Attorney General with the case, and if the Attorney General doesn't bring the case, the citizen can bring the case, and then if damages are awarded, they can share in those damages, I think, up to 25%. So that creates an incentive for people to look for this type of problem, bring it to the Attorney General, and if they don't get relief there, to bring a suit. So obviously, many things going on in this law, and an important thing to keep your eye on as it goes through the process. Turning back to the concerns just about breach of information, the New York Department of Financial Services has been a leader in this space. It issued its own cybersecurity rules effective in 2017. I think it did this in frustration with the federal government. It believed that the federal government wasn't really being as specific as it ought to be in terms of cybersecurity. To date, most of the federal cybersecurity provisions are fairly high level in general and really address the need to have policies and procedures. But I think New York took it to another level with more detail, and that's something that we see other states copying. If we have time, we'll talk a little bit about that. Advertising reviews. Keep in mind that, again, as I mentioned a little while ago, the use of social media is on the rise, and it makes total sense because as younger and younger people come into the mortgage market, we expect this is how they want to shop for a mortgage. This is how they want to find a realtor, a broker, a lender, and this is the way to meet them where they are. But it can also be fraught with regulatory risk. All the states have acts that address deception in advertising. The Federal Trade Commission, even though it is now headed by a President Trump appointee, continues to be very active in the advertising space. It recently had a settlement with Lending Club for advertising around no-fee loans. That wasn't a mortgage action, but it shows you that the Federal Trade Commission continues to have its eye on advertising, and it has a long history of partnering with states and sharing information with states under MOUs to address these sorts of problems. So very important to have a social media policy and then to enforce that policy however you decide to set it, whether you'll let people go ahead and advertise freely or whether you want everything to come through a centralized place. This is an important area. In addition to those laws on deception that are very broad, we also have a lot of specific requirements that I see people, frankly, screwing up on quite frequently. And one of them is just missing the NMLS ID in something on Twitter or Facebook that sure looks like an advertisement or a commercial communication to me. So you need to keep your eye both on the general deception issues, but you also need to keep your eye on the specific requirements. And then lastly, remember that the attorneys general can enforce RESPA Section 8, and there are a lot of instances of people posting things on Twitter and Facebook or Instagram about preferred partners, and that could be a signal to a staffer at a state attorney general's office that they ought to look more deeply into this, and is this some sort of kickback scheme between, say, a mortgage originator and a real estate broker. So an area, again, to keep your eye on with the states.
And in addition to, bear in mind with all of this advertising and use of websites that some states, New York, for example, you've got to seek the state's authorization before using websites and get their approval to what you're doing. So you want to be aware of those state requirements. So next up, and Dustin, the slide's not moving for me. We've got unique state-specific hot topics, thank you, that we want to go to, and want to be sure we cover these. So very quickly, I'm just going to remind folks that each state, of course, is unique. You want to have an approach on exam management and communication, stay abreast of these regulatory changes, and monitor any enforcement activity. And that's pretty critical to know. And next slide, please, Dustin. So what we'd like to do is to give you some specifics on some of these individual states. Very quickly, just some little hot topics for you to note. I'll let Kitty kick us off with the first couple.
Sure, I'll go quickly here because we're running out of time. But on the continuing theme that I was on a minute ago with cybersecurity, Arizona is a state that had, I think, one of the probably the narrowest cybersecurity provisions, and has recently now broadened it. I expect that the states will be maybe in competition to see who can have the broadest rule, but they have now recently broadened it out, and they have been very clear on when they expect an entity to provide a notice of breach, and it's within 45 days. That's been one of the big concerns out of all the big breaches, that these breaches occur, and those impacted don't necessarily know, sometimes for months, that it has happened. And so in order to arm consumers with the ability to protect themselves, Arizona is taking a very strong stand in terms of when a breach notice has to go out. I've talked a little bit about California, and we've mentioned their interest, no pun intended, on per diem interest. This continues to be a routine finding. It's the basis for some consent decrees. They really take it seriously, and I think we'll continue to see that. They have their own advertising requirements. I think we can expect them to be looking for violations of those. As I mentioned a few minutes ago, the ease with which a regulator can see how well your advertising policy is working is simply by surfing social media. So it is out there for everybody to see. And then just switching horses for a minute, in New York, I just want to highlight for everybody that they recently amended their loss mitigation notice requirements for mortgages to specifically include reverse mortgages in them. This has been, they were excluded in the past in New York. In some states, they have loss mitigation requirements that are not clear as to whether reverse mortgages are included. And it can be a real pain point for compliance because of the difference between reverse mortgages and forward mortgages. So, Monika, I'm going to give you the last word here.
And
Great.
Monika,
So
we have 2 minutes remaining.
Great. Thanks, Marty. So for Idaho, for example, what you can look for is examiners that are checking the Secretary of State website for other employment of your employees, and then going to the NMLS Other Business to see if any other employment is disclosed. And you should note that the other employment or other business doesn't have to be employment in the real estate finance field. It applies to any employment. And Idaho also has a broad interpretation for control persons for NMLS, and so you may really want to be cautious to limit who you're indicating has authority to act on behalf of the company, and unlicensed activity is a big issue as well there. In Oklahoma, we're seeing here another one where their exam info requests are very extensive. And in Oregon, what we've heard a lot of folks being challenged by is the requirement for personnel records, where the employer has to maintain a personnel ledger, which contains the name, date of birth, position or title, and responsibilities, starting date, date and reason for termination of salaried employees, and also this includes independent contractors and consultants who are involved in loan origination, loan servicing, loan negotiations, investor solicitations, and those who transact business with borrowers. And so it's a broad definition, and these ledgers can be challenging to have to pull together. And so you want to take a close look at what they are requiring before you have to provide them in the exam. And then in South Carolina, what we are seeing is that they have an attorney insurance preference disclosure requirement. And again, it's required to be delivered within 3 days of the application date. And the borrower is supposed to identify their preference for both the attorney and the insurance agent on the disclosure before closing. And the issue that one of our CMBA members had was that this disclosure was not being completed by the borrower. The attorney and insurance agent names were left blank, and the attorney preference being left blank may potentially lead to refunding the closing fees on all affected loans. And again, once one individual state sees this, it may be out there for others. And then in the state of Washington, we're just seeing a real focus on DBA and trade names. And so take a look at that and be sure that you are compliant with their specific regulations. And they are also a stickler on advertising review. So you want to be sure you're looking at their statutes before you have that exam and complying with them. So let me turn it back over to Marty, because I know we are out of time. I'm only seeing one question in the queue, and I think that question is whether the DBO is offering multi-language translation templates for loan mods, and I think that's going to be tied to and timing with the recent regulation. So back to you, Marty.
Okay, great. Thank you so much, Monika and Kitty. Appreciate you being our speakers today. Great information and lots of takeaways for us to go back and review our specific state requirements. I really appreciate you speaking for us today. I just want to make sure everybody's aware our next webinar is June 28th, and we're going to discuss internal audit requirements. Again, please tell your colleagues and friends so they can join us on June 28th. And you're right, we are out of time, so we're going to sign off and say goodbye. And again, thanks for everybody for joining. And thanks to our speakers, Monika and Kitty, and also to Pat and Michael, as usual. So thanks, everybody. Have a great afternoon, and we'll see you next month.